The gentleman is recognized for 5 minutes.
I want to urge all of our colleagues to reject this weak and unconstitutional motion to recommit. The motion proposes to condition the admission of Washington Douglas Commonwealth on either the imposition of the whimsical policy preferences of the minority or simply banal restatements that the state will follow federal law, which obviously it must do already under the supremacy clause of the Constitution. All of the states must. But the paradigm example here, and the thing that really appears to be on their mind, and I'm glad we at least have boiled it down to this issue, is they want to make sure that the new state doesn't come in without an amendment written by the people of Washington, D.C., saying that they will not charge people a fee for carrying a concealed weapon. Now, that is not in the U.S. Constitution, and it's not a matter of federal law obligating the states, the 50 states, to do it. So you cannot selectively impose that on the new state of Washington, D.C. That is the equal footing doctrine, which the Supreme Court has emphasized repeatedly throughout our history, that every new state that we've granted admission to since the original 13, all 37 have entered on the exact same plane of political and constitutional equality as the original 13. And so they want to impose their various policy preferences on different things like the concealed carry weapons and so on. If you want to do that, then try to pass it for the entire country, and it would apply within the new state as well. I don't think you can do it constitutionally, but that's a separate matter. Or resign your seat from wherever you happen to be from. If you're from Georgia, resign your seat in Georgia, move to the new state, and then campaign as a member of Congress from here, or campaign for governor or state legislature in the new state, and get them to change their law, because that's a matter of local policy. And I would think that the great champions of federalism and state rights would want to allow every state to make a decision for itself. Mr. Speaker, a number of things have been said that need to be corrected. For one thing, my friend from Texas, Mr. Royce, said that we should legislate for the real Americans, and he's going to speak for the real Americans, not the people who live in Washington. I would hope he would reflect on that and issue an apology to the people of Washington, D.C. But it seemed that the logic of the argument was that the only people who live here are federal employees, and they're different from the rest of America. Now, think about that for a second. In the first place, the overwhelming majority of federal employees do not live in Washington, D.C. As far as I could tell, less than 8% of federal employees live in Washington, D.C., which means 92% of them live in our states. In the rest of America, should those people be disenfranchised? Should people work for the post office lose their right to representation in Congress? Should members of the armed forces be disenfranchised? The Supreme Court already said no in Carrington versus Rash. So check it out. So the overwhelming majority of federal employees don't live in D.C., and the overwhelming majority of people who do live in Washington, D.C., and are the constituents of Representative Norton are not federal employees. They do other things. Yes, they are real Americans too. They are bus drivers, they are school teachers, they are business people and entrepreneurs. I mean, come on, get real, be serious. Get out and meet the people in Washington. The gentleman from Georgia said Washington, D.C. was set aside in the Constitution as a federal district, and that was echoed by the former judge from Texas. But here our friends just advertise their unfamiliarity both with the Constitution and with American history. The Constitution does not fix the geographic site of the so-called seat of government, the district that's set aside for the seat of government. That's why, after the Constitution was adopted, the capital was in New York for a while. It was in Philadelphia for a while. And before that, it was in Trenton, New Jersey. It was in Princeton. It was in Annapolis. We have a whole room in Annapolis set aside for where Congress met. So the idea that you can look up the Constitution and see the boundaries or the map of Washington, D.C. is just absurd. Now, does Congress have the authority to modify the boundaries of the federal district as proposed by Ms. Norton? Of course it does. We voted to do that in 1846 at the behest of a couple hundred of slaveholders in Virginia who were afraid that this Congress would follow the advice of Representative Lincoln from Illinois, who said abolish the slave traffic in Washington, D.C. And they were afraid it was going to happen. So Alexandria, Arlington, Fairfax County were given back to Virginia. And it was perfectly constitutional. and there is no legal authority to the contrary in any way. If we can modify the boundaries of the federal district to placate a couple hundred slave masters from the 19th century, we can modify the boundaries of the federal district to grant statehood and political equality for the people of Washington, D.C. I yield back.